Have you ever wondered why strong VAWA cases still get denied? Most people think that the hardest part is proving abuse, but it's not. The hardest part is everything you do before you file. I have filed hundreds of successful VAWA cases over the past 16 years, and I can tell you this: the biggest mistakes happen long before USCIS even sees your case. So in this video, I'm going to walk you through the 9 things you must absolutely do before filing for VAWA, the hidden risks that can destroy your case before it even starts, and the best ways that you can protect yourself from day 1. Step 1, confirm that you qualify. To start, I'm going to show you how to make sure you actually qualify before filing. This is the most important first step because if you get this wrong, you could find yourself in removal proceedings. First, VAWA only applies in certain relationships. This means in order to qualify, you must be the spouse of a U.S. citizen or a green card holder, the parent of a U.S. citizen who is at least 21 years old, or the child of a U.S. citizen or a green card holder. And if you're filing based on marriage, then the marriage must be legally valid. This means you have a real marriage certificate and that all of your prior marriages, both yours and your spouse's, must have been properly finalized. Now, if you are already divorced, the timing is critical. You must file within 2 years of the date that the divorce became legally final. This is a hard deadline. Go even 1 day beyond, and USCIS will deny you immediately. And here's another rule that surprises people. If you remarry before your I-360 is approved, your VAWA case will also be denied automatically. So hold off until after your case is approved. Also, keep in mind that you need to have lived with your abusive relative at some point, and the abuse must have occurred during the qualifying relationship. If these elements are not here, USCIS will not approve your case. Finally, before you file, take a serious look at your criminal and immigration history. Pull your FBI background check and get certified court dispositions for any arrest, even if it was dismissed. Review any prior immigration filings to make sure your dates and information are consistent, because filing without understanding your full history is asking for trouble. Now, once you know you qualify, the next step is protecting yourself before you file, because even though VAWA is confidential, you still need to make sure that you are safe from your abuser and immigration. So before you submit anything to USCIS, think about where your mail is going and who has access to your personal information. If you are still living with your abusive relative, do not use your home address for USCIS correspondence. You can use your attorney's address. You can get a P.O. box, and in some states, you can even enroll in an address confidentiality program, which makes it impossible for your abuser to discover the address you use. You should also secure your digital life. If your spouse has access to your phone, your email, or your cloud storage, assume that they can see everything. I recommend creating a new private email account for your VAWA case, and if it's safe, change your passwords. Turn off location sharing. If you suspect spyware or monitoring, use a separate device for communications about your case. You also want to go through your social media because USCIS can review whatever is publicly available. If your posts contradict a timeline, then you may have problems in your case. However, when cleaning up your social profiles, do not delete evidence of abuse. If there are threatening messages, keep them. That is strong evidence that can help you prove your case. Now, most people don't think about this step, and that's exactly why they get denied. Before you file for VAWA, you should request a copy of your entire immigration case through a FOIA request. This is called your A file. Your A file contains every application that has ever been filed on your behalf, including old I-130 petitions, I-485 applications, work permits, other background checks, and sometimes officer notes. The reason you would want it is because if you file a VAWA application that contradicts something you previously told USCIS, even if it was years ago, they will notice and call it an inconsistency. Some of the details they'll compare include addresses, dates of residence, dates of marriage, dates of entry and exit, statements about your relationship, and if they see inconsistencies that you cannot explain, it can damage your credibility. I have seen cases get denied simply because an old I-130 listed a different move-out date than what was written in the VAWA affidavit. This is avoidable. However, a FOIA request takes many months, sometimes even up to a year, so you will want to give it some thought about whether this is the right move. However, filing this gives you a chance to review your history before USCIS does. Okay, now, if you have children, this next part is critical. If your child is under 21 and unmarried, they can usually be included as a derivative on your VAWA application. This means that they can receive immigration benefits through your case without filing their own I-360. But this also requires planning. You will need their birth certificates. You may also need school or medical records. And if those documents are overseas or in the possession of your abuser, it can take time to replace them. Timing also matters. If your child is close to turning 21, you need to move carefully because if they age out, it can affect their eligibility. So start thinking about this as early as possible and time your application accordingly. Okay, this next step is a big one and will help prevent unnecessary RFEs. I am talking about preparing documents. If you submit your case without one of the following documents categories, it can still be approved, but it's going to be more challenging. The first category is proof of the relationship. If you are filing as a spouse, USCIS must believe that this was a real marriage. That can include joint tax returns, shared bank accounts, insurance policies, listing each other, and photographs over time. Second is proof that you have lived together. Shared residency is required under the law, so these documents are critical. You can prove it through leases, mail sent to the same address, school records, or statements from neighbors. Third is documentation supporting the abuse. You do not need a police report, but it is good to have something that supports your claim. This could be a medical record, a counseling record, threatening messages, or declarations from people who witnessed what was happening in your life. If you do not have any of these, you can still prove your case through your affidavit, which I'll explain in just a moment. Fourth is proof of good moral character. This could include background checks, tax filings, and letters from employers or community members help show that you meet this requirement. You also need documents confirming your identity and that you are physically present in the United States when you file. Your passport, government-issued ID, and recent proof of address are all key here. And finally, you must prove the immigration status of the abusive relative. If USCIS cannot verify that the person who harmed you is a U.S. citizen or a lawful permanent resident, they cannot approve your petition. Note that if you try to obtain a document but cannot get it, keep a written record of your attempts. Remember, USCIS must accept any credible evidence, so showing that you tried matters. If you want to go into even more detail about the types of documents you need to prove and how to prepare them, watch my other video, How to Win Your VAWA Case in 2026. I'll include a link to that here at the end of this video. Now, once your documents are in order, the next thing you should do is build a timeline. Abuse cases can often span years, and trauma can make details difficult to recall. So creating a timeline helps you rebuild the order in which things happened. It also helps prevent any inconsistencies in your case, which is key to getting approved. So sit down, start at the beginning of the relationship. When did you meet? When did you start living together? Then move forward chronologically. You don't need to know exact days, months, and year is usually enough. For each event, remember, write down what happened, where it happened, city and state if possible, whether anyone else was present, whether police were called or medical care was sought, and also if you separated then, record the move-out date clearly. If there were temporary separations, note those as well. Shared residence timelines will be closely reviewed by the officer assigned to your case. Another thing that they will be looking into for is patterns of control. Many abusive relationships involve repeated behaviors that happen over long periods of time. Things like constant criticism, controlling money, isolating you from your friends, monitoring your phone, and threatening your immigration status. These kinds of behaviors are recognized as forms of coercive control and can qualify as extreme cruelty. So if something happened repeatedly, write down when it started, for how long it continued, and for example, if your spouse regularly threatens to withdraw your immigration papers or call immigration authorities, note when those threats began and how often they occurred. That way, when you look at the full timeline, you should be able to see how the relationship developed and how the control increased over time. Next, we need to talk about the most important part of your VAWA case, your affidavit. This is the backbone of your case. I have seen two people go through almost identical abuse and only one receives approval simply because they had the better affidavit. So don't rush this. The timeline you created in the last step will give you the structure. Now your job is to explain what those events actually meant. Like I said, USCIS is not looking at whether arguments happened or whether they were isolated incidents. Officers are trained to evaluate patterns of power and control. They want to understand the abuse and how it affected your life and how the abuser used fear, pressure, isolation, or immigration threats to maintain control. So your affidavit should walk through the relationship from the beginning to the end and paint that picture. You want to detail how the relationship started, when the behavior began, how the control escalated over time, and how that control affected your daily life. Simply writing, "He yelled at me" or "She insulted me" is not enough. You need to explain the context and the impact. Did you stop seeing friends? Did you become afraid to ask for money? Did you avoid speaking up because you were worried about immigration threats or consequences? These are the kinds of details that officers will use to help approve your case. And that is why I simply do not have clients write something quickly and send it in. In my office, we spend hours going through the timeline together, sometimes over multiple meetings. We look for the details that reveal the pattern of control and the real impact of the abuse. Because when this part is weak, the entire case becomes vulnerable. But when it is clear, it can be the deciding factor. So slow down here. Take the time to get this right before you file step 8. There is one more tool you should consider before filing, and that is a psychological evaluation. Research shows that immigration cases supported by forensic psychological evaluations are approved at significantly higher rates than those without one. That is because it adds an independent, licensed professional who documents the impact of the abuse in clinical terms that USCIS officers are trained to evaluate. If your case lacks police reports, hospital records, or other traditional documentation, this can be especially important. It is not required in every case, but in the current environment where officers are scrutinizing credibility much more closely, this can significantly improve your chances of success. That's why in my practice, we usually help our clients obtain one before filing. Finally, let's talk about whether or not you should try and file the VAWA by yourself. Technically, you are allowed to file a VAWA case without a lawyer, but you should be careful because this is your future. If your case is straightforward, no criminal history, no prior removal orders, no immigration denials, then you might be able to prepare a strong case on your own, but it is going to require a lot of work and a little bit of luck. On the other hand, if you have ever been arrested, if you have ever been in immigration court, if you have ever had a prior petition denied, or if you have inconsistencies in past filings, then filing on your own can be incredibly risky. That is because even something that seems minor on paper can have major consequences in immigration law. But a good immigration lawyer with years of experience filing VAWA cases can massively increase your chances of success. Among many other things, they know how to prevent a criminal record from getting your case denied. They also know how to prepare the evidence in your case the right way. And they know how to structure your affidavit so it convinces the USCIS officer assigned to your case. So yes, you are allowed to file on your own, but if your case has any complication, even one, this is not the place to gamble. This is about your ability to live and work here in the US. This is about protecting your future. And when the stakes are high, getting it right the first time matters. My name is Moumita Rahman, and for the past 16 years as an immigration lawyer, I have successfully filed hundreds of VAWA cases. That means I know exactly what USCIS is looking for when deciding your case and what you need to do in order to get it approved. So if you would like my help, you can give me a call and schedule a case evaluation at 212-248-7907. We are based in New York, but serve clients across the US. Now, everything we covered is about preparing before you file, but preparation alone doesn't win a VAWA case. It is only half the battle. So in my other video, How to Win Your VAWA Case in 2026, I break down exactly how USCIS is evaluating cases right now, what officers are trained to look for, and how to structure your evidence and affidavits so your case checks every legal box. If you're serious about getting this approved, especially under the current administration, then you won't want to miss this video. I'll include a link to that here. Click to watch it next, and I'll see you there.